बिस्मिल्लाहिर्रहमानिर्रहीम। जीअं त अॼु असां चैप्टर नंबर जेको आहे 16 पढ़ंदासीं ऑफ कंप्लेनेंट्स टू मजिस्ट्रेट। CRPC जीअं त 200 जेको आहे एक्समाइनेशंस ऑफ कंप्लेनेंट, अ मजिस्ट्रेट टेकिंग अ कॉग्निजेंस ऑफ एन ऑफेंसेस on complainant and shall at once examine the complainant upon oath, and the substance of the examination shall be reduced to writing and shall be signed by the complainant and also by the magistrate. हाणे इहा HEC में जेकी डेफिनेशन आहे, स्टेटमेंट अची चुकी आहे। मजिस्ट्रेट खां वेंदे लास्ट जेको वर्ड मजिस्ट्रेट आहे इहो माना पहिरियों लॉ गेट में अची चुको आहे। प्रोवाइडेड एज फॉलोज़: when the complaint is made in writing, nothing herein contained shall be deemed to require a magistrate to examine the complainant before transferring the case under section 192, sending to it to the court of session. When the complainant is made in writing, nothing herein contained shall be deemed to require the examinations of complainant in any case in which the complainant has been made by a court or by a public servant acting or purporting to act in the discharge of his official duties. When the case has been transferred under section 192 and the magistrate so transferring it has already examined the complainant, magistrate to whom ऐं हिन खां पोइ जेको सेक्शन आहे 201 आहे, प्रोसीजर बाय magistrate not competent to take a cognizance of the case. If the complainant has been made in writing to a magistrate who is not competent to take cognizance of case, he shall be return the complainant for the presentation to the proper court with an endorsement to the effect. and इन में जेको हिकिड़ो लफ़्ज़ आहे to the proper court with an endorsement, इहो MCQ अची चुको आहे लॉ गेट में। If the complainant has not been made in writing, such a magistrate shall direct the complainant to the proper court. Postponement of issue of process: any court or receipt of a complainant of an offence of which it is authorized to take a cognizance, which has been sent to it under section 190 subsection 3, transferred to it under section 191 or section 192 may it thinks fit for reason to be recorded postpone the issue of process for compelling the attendance of the person complained against the and either inquire into the case itself or direct an inquiry or investigation to be made by any justice of the peace or by a police officer or by such other person as it thinks fit for the purpose of asserting the truth or false of the complainant, provided that say where the complainant has been made by a court on number such a direction shall be made unless the complainant has been examined on oath under the provisions of section 200. and इहा जेकी स्टेटमेंट आहे इहा गेट में अची चुकी आहे पहिरियों, यानी कि court of session may in a state of directing an investigation under the provision of subsection 1 direct the investigation to be made by any magistrate subordinate to it for the purpose of asserting truth or falsehood of the complainant. इहो truth or false में अंडरलाइन कजो, इहो पहिरियों MCQ अची चुको आहे लॉ गेट में। या if any inquiry or investigation under this section is made by a person not being a magistrate, justice of the peace or the police officer, such a person shall exercise all the powers conferred by this code on an officer in charge of police station, except that he shall not have power to arrest without warrant. Any inquiry into a case under this section may it thinks fit to take evidence of witnesses on oath. Dismissal of complainant: the court before whom a complainant is made to whom it has been transferred or sent may dismiss the complainant if after the considering the statement or oath if any of the complainant and the result of the investigation or inquiry of any other under section +, there is in his judgment no sufficient ground for proceeding. In such a case he shall briefly record his reason for so doing. उन खां पोइ कंप्लेनेंट इन केस ऑफ ज़ना 203A No court shall take cognizance of offences under Section 5 of the Offences of Zina, Enforcement of Hudud Ordinance 1979 except on a complainant lodged in a court of competent jurisdiction. The presiding officer of court taking a cognizance of an offence and a complainant shall at once examine on oath the complainant and at least 4 Muslim adult eyewitnesses about whom the court is satisfied in regard to the requirement Tazkiyat al-Shahud that they are the truthful person and abstain from the major sin, Kabira of the act of the penetration necessary to the offences, provided that if the accused is non-Muslim, the eyewitnesses may be non-Muslim. In this section, Tazkiyat al-Shahud means mode of inquiry adopted by court to satisfy itself as to the credibility of witnesses. The substance of the examinations of complainant and the eyewitness shall be reduced to writing and shall be signed by the complainant and the eyewitnesses and also by the presiding officer of court. If in the opinions of presiding officer of court there is sufficient ground for proceeding, the court shall issue a summon for the personal attendance of the accused. The presiding officer of court before whom a complainant is made or to whom it has been transferred may dismiss the complainant if after considering the statement on oath of the complainant and the 4 or more eyewitnesses there is in his judgment no sufficient ground for the proceeding. In such a case he shall record his reason for so doing. Baso Trey complainant case of Qazaf subject to subsection 2 of section 6 of the offences of Qazaf enforcement of Had ordinance 1979 में of no court shall take cognizance of offence under section 7 of the said ordinance except on a complainant lodged in a court of competent jurisdiction. The presiding officer of court taking cognizance of an offence on a complainant shall at once examine on oath the complainant and the witness as mentioned in section 6 of the offences of Qazaf enforcement of Had ordinance the act of Qazaf necessary to the offence. The substance of the examinations of complainant and the witness shall be reduced to writing, shall be signed by the complainant and the witness as the case may be and also by the presiding officer of the court. If in the opinions of presiding officer of court there is a sufficient ground for proceeding, the court shall issue summons for the personal attendance of the presiding officer of court before whom a complainant is made or to whom it has been transferred may dismiss the complainant if after considering the statement on oath of the complainant and the witness there is in his judgment no sufficient ground for proceeding, and in such a case he shall record his reasons for so doing. Baso trace jeko asan complaint case of fornication, no court shall take cognizance of offence under section 496B of the Pakistan Penal Code except on a complainant lodged in a court of competent jurisdiction. The presiding officer of court take cognizance of an offence shall at once examine on oath the complainant at least 2 witness to the act of fornication. The substance of examination of the complainant and the witness shall be reduced to writing and shall be signed by the complainant and the witness as the case may be and also by the presiding officer of the court. If in the opinions of presiding officer of court there is sufficient ground for proceeding, the court shall issue a summon for the personal attendance of the case, provided that the presiding officer of court shall not require the accused to furnish any security except personal bond without surety to ensure the attendance before the court in the further proceeding. The presiding officer of court before whom a complainant is made to whom it has been transferred may dismiss the complainant if after considering the statement on oath of the complainant and witness there is in a judgment no sufficient ground for proceeding. In such a case he shall record his reasons for so doing, not withstanding the foregoing provision anything contained in any other law for the time being in force. No complaint under this section shall be entertained against any person who is accused of zina under section 5 of the offences of zina enforcement of Hudud Ordinance 1979 and against whom a complaint under section 2A of the code pending has been dismissed or who has been acquitted against any person who is an complainant or victim in a case of rape under any circumstance or whatsoever.